Hello, everyone, and welcome to the Vegas Legal Magazine podcast. I'm Mark Fierro with Vegas Legal Magazine publisher Tyler Morgan, Fierro Communications Vice President Jeff Haney. Thank you so much for joining us today. Our guest today, Vincent Savarese III, known as Vinny in Las Vegas, partner at the firm of Gentile, Cristalli, Armeni, and Savarese. He joins us to talk about this week's raid on the offices of Michael Cohen, President Trump's longtime lawyer. Vinny is highly experienced in search and seizure law. He was involved in that landmark case involving the 2013 seizure of $167,000 in cash from the driver of a motorhome by law enforcement during a traffic stop near Elko. Ultimately, in 2017, the Ninth Circuit Court of Appeals ruled that the search of the motorhome was unconstitutional. So, today, a little bit in that background, talking about search and seizure. Mm-hmm. Thank you so much for joining us today. And,
you're welcome.
This is a barn burner of a case.
Sure is.
When it comes right down to it, if your attorney has an attorney, and your attorney has his premises, his home, and his office searched by FBI, that's not good, right?
And hotel room.
Yes, and that's not good, right? Just for the record.
Probably not good.
Probably not good.
Most circumstances.
This is one of the tallest hurdles for a prosecutor to get over, right? When you're talking about attorney-client privilege.
Law office searches.
Yes, and it's very rare. In this case, how did they get around that? How did they manage to get around
Well, first of all, to obtain a search warrant for any lawyer's office, you have to get special permission from the Department of Justice for the FBI to go carry out a search in a lawyer's office, because obviously it involves attorney-client communications are going to be examined, documents. Other clients of the lawyers, they're going to encounter, they're going to see materials that pertain to other cases of the lawyer that have nothing to do with this investigation. It's sensitive. A lawyer's office contains much confidential information, privileged information. It could very well impair the effective representation of the client that's in question, and other clients as well. So because of the special sensitivity to that kind of possible collateral damage, they have to get special permission. In addition, a judge who's being requested to issue a search warrant for a lawyer's office is required to give heightened scrutiny to the sufficiency of the underlying showing of probable cause alleged in order to obtain that search warrant. So as in any search warrant scenario, an application is filed with the United States magistrate, which is supported by a sworn affidavit, usually by an investigating agent. In most federal cases, it would be an FBI agent that's running the investigation. And we'd have to set forth facts and circumstances, not speculation, but facts, from which a neutral and detached judicial officer can infer that there is probable cause to intrude upon the privacy of those premises. What that requires is a showing that evidence of a crime, that there is reasonable grounds to believe that evidence of a crime will presently be found on particular premises at this time. Now, that's required in every search warrant. In a law office search, though, where attorney-client communications, whether they're written or otherwise memorialized or something that can be found and pierced, there would have to be, it seems to me, a finding that the attorney-client privilege may likely not apply in this particular case. And by that I mean not every attorney-client communication is privileged. It has to be a communication, a confidential communication pertaining to the representation. So it can't be as a lawyer. So it can't be you have a lawyer that's your business partner in an unrelated matter.
Or a fixer, as he claimed himself. He titled himself a fixer. He said specifically that he stepped outside the role of attorney.
He did. Well, you know, that is colloquialism, and it may, you know, he may not necessarily attribute it to it the sinister sort of gloss that I think most people may attribute to a statement of that nature. But there's an exception to the attorney-client privilege where the attorney and the client are communicating, that their communications are facilitating a crime of some kind or an illegal cover-up of a crime to avoid detection or otherwise constitute what they call the crime-fraud exception to the attorney-client privilege, which is pierceable.
If you're involved in leg breaking, which is not alleged here, but if you're involved in leg breaking, that's clearly not covered under attorney-client.
Well, that's not true, because if a client admits to his lawyer, I broke this guy's legs, and I'm charged with breaking his legs, and I did break his legs.
But if the attorney says on Tuesday, let's make sure that we get this leg breaking done, that's an entirely different case. And
right.
And for just to put this in perspective, if you ask 100 people today if this is Mueller's work, they'd say, it's that damn Mueller. This is not Mueller's work. Mueller handed this off, and it's the Southern District of New York, right? Federal judge, and it's his imprimatur that
It's my understanding that the U.S. Attorney's Office there is heading this up. But it's also information that undoubtedly will be shared with the Mueller investigation.
So with all that in mind, why do you think the Justice Department may have acted so aggressively in this particular case? I mean, it appears to be an extraordinary series of events.
It's very rare, particularly. Not only is this a law office search, but it's a lawyer for the President of the United States.
This is not about Cohen. This is about the President of the United States.
Well, you know, I don't know whether that's going to prove out to be the case or whether that's what's been shown to the judge. The focus of the investigation and what's been given to the issuing judge that gave the warrant may focus exclusively on Mr. Cohen.
And his $130,000.
That, and I don't know what else. I understand from what I'm reading that what was taken seems to go well beyond that. Undoubtedly, the affidavit in support of the search warrant remains under seal. If any fruits of the search are ultimately presented to a grand jury and result in criminal charges down the road, that application for search warrant will become unsealed, and not until then will you know what this judge was told. But whatever it was, I am personally, and I've got 38 years of experience doing these kinds of cases, and I'll tell you this. There had to be a pretty strong showing made for a U.S. magistrate to issue a warrant to search the law office of the president's lawyer. It's not going to be given out on borderline allegations, inferences, speculation, or conjecture. I mean, there had to be something pretty specific that was in that application. That would be my guess, at least.
Well, the reports are they seized emails, tax documents, and business records, along with records related to the payments to the two women who claimed affairs with President Trump. And the latest report is also records related to the infamous, I should say, Access Hollywood tape.
Right.
That's the latest report from today,
right,
which is quite interesting considering that very, very shortly after the Access Hollywood tape came out and was released to the public in the lead up to the election, WikiLeaks released the Podesta emails.
That would be as in the same day, right? It's contemporaneous.
Within hours, yeah.
That's one way to spike a story, come with a better story.
Right, and the speculation has always been that perhaps those two events were related in some way.
I don't know. That's
and
pretty suspicious.
with today's news, there's going to be, of course, further speculation that it was arranged, perhaps.
At this point, I would have to say that as a lawyer, I'd characterize all of it as speculation.
Yeah.
I don't think there's anything in the public domain yet that's certainly specific enough for me to draw any particular conclusions. Although I will say that it is a highly, highly unusual, extremely extraordinary investigative step. That's for sure.
Now, if you're on the side of the president in this situation, what can the president do, or what do you think he's likely to do with his, because he's got the appointment clause and everything, to sort of circumvent and trying to bog down this investigation, make it more difficult for the FBI and the Southern District to proceed?
Well, there's nothing that he can do about what's been done to date in terms of seizures have been made. They've been made under a warrant. Search warrants are presumed to be valid. The burden is upon an aggrieved party who wants to challenge the legality of a search warrant to demonstrate that the warrant is somehow defective. But there are two considerations here. He can move, if it results in some sort of an indictment, if its criminal evidence was in fact seized and implicates the president or Mr. Cohen, a motion to suppress that evidence can be filed in court, similar to the case you just discussed that I had that you referred to in the Ninth Circuit. That's a motion to suppress evidence. But in the court of public opinion, I don't see that matters a whit, because whatever is found and exposed and publicized, if it is derogatory, then it's going to have an inexorable political effect, regardless of whether or not it's ultimately considered admissible in a court of law. I just don't think it would be very good for the president if evidence supporting a criminal allegation is found, even if it's ultimately found not to be admissible in a court of law.
Yeah, long before you get to the courthouse steps.
Right. The other thing that may happen, if this falls flat, and nothing was derived that's necessarily constitutes a smoking gun or anything like that, I would imagine I wouldn't be surprised if the president then may take some kind of dramatic action in terms of addressing your question, to sort of derail the investigation by
Start firing people.
by the Saturday Night Massacre kind of Nixon-esque sort of a situation in which he may demand that the Deputy Attorney General Rosenstein or Steen, I don't remember. Rosenstein fire Mr. Mueller, and he may do so in a tirade of exasperation. He's already called this disgusting and a threat to the American way of life. These kinds of things, investigations of this nature, searches and seizures are performed all over the United States every day in criminal investigations. The president enjoys no particular immunity from criminal investigations, and the Nixon case made that very clear.
Yeah, that ultimately didn't work out well for Nixon either when he caused heads to roll. He may have thought it was going to, but in the end,
well, I think that
flames.
Mr. Trump, this is apolitical. It's just a personal observation. I think that similarly, I think he reflects a sort of an imperial view of the presidency, that if individuals in law enforcement are investigating him, that somehow reflects an unacceptable disloyalty, regardless of whether or not the investigation has legs, or whether these individuals are faithfully performing their duties.
Well, I think that last time he fired somebody, he ended up with Mueller, so that didn't go so well for him. He went from a grease fire to a nuclear reactor.
It seems like he's blaming Jeff Sessions for this whole thing. Ultimately,
he may be the only guy on earth that could turn Jeff Beauregard Sessions into a hero. That's a pretty tall cotton right there.
He's like sort of saying, well, if you hadn't if you'd have told me that you were going to recuse yourself from this Russian thing, then I'd have never put you in as Attorney General, and I would have gotten somebody more that didn't have to recuse himself, that would do what I tell him to do.
Well, that comes back to his emphasis on personal loyalty at the expense of everything else.
Yeah, regardless of whether the agents or the investigators or Mr. Mueller are in fact performing what they perceive to be their legitimate duties, I think Mr. Trump may perceive that in any case as an act of disloyalty.
Well, it's almost like, hey, the Attorney General isn't there to uphold the laws of the land. He's there to be, to serve as my henchman, essentially.
And Democrats are
fixer, as it were.
Yeah, fixer. But the other guy was a fixer. Why can't you be a fixer for me? The Democrats have consistently missed the opportunity, and that is to poison the well. To poison the well thoroughly ahead of time. They know what's coming. They suspect what's coming. They keep repeating over and over and over again that they have to do something to create a firewall against Mueller being fired. And from the political perspective, I think what they should be talking about is that he's going to keep firing some people in the Justice Department until he finds someone that holds Donald Trump above the Constitution of the United States. And that'll be the one thing that'll keep him from firing the first guy. Because that's what it comes down to. That's
find his Robert Bork, as it were.
Yeah, exactly. Find his Robert Bork. Bork was absolutely willing to do that and paid the ultimate price. He didn't get the
Supreme
seat
Court
as a result of that. And last time I heard, that was a pretty good gig. So it's interesting for our audience. You come to this from probably the highest tests, the reason that we turned to you. In the old days of the big drug guys, the massive drug guys, when the very, very best attorneys, that was where the law was. That was what was going on, what was important in the law. And search and seizure, 99 times out of 100, was the only way that you could beat a trafficking case or anything like that when they had this mountain of drugs and it's into the guy's property. So you had to be able to drill down into search and seizure, and you were one of the leading experts on search and seizure, and that's why we turned to you. Tell us about this other case, if you would, for a moment. We've talked about it on an earlier podcast, that nefarious $167,000, the United States versus $167,000.
Right.
Yeah, I think the judgment came out after we did the interview with him.
The final.
So you can update us.
Well, we had won the case originally in the federal district court in Reno, and then
let's lay out from the beginning. So your client is driving down a highway in the no man's land in Nevada. Is out there, he gets pulled over just because he's got an RV and he's driving alone. And this is a path that drug traffickers take.
Yeah, on I-80, the I-80 corridor going across northern Nevada, westbound toward Northern California, in a high-profile vehicle, and as the officer testified, at the hearing we ultimately had in the case, I am not relying on this, but I do pay attention to large vehicles heading northbound heading to Northern California as a vehicle that may be en route to pick up a marijuana load,
yes,
and who may therefore have considerable amount of cash on board to make a purchase of that nature. All of this is not sufficient to stop or detain a citizen, but in this case there was an alleged traffic violation, which is a sufficient basis to stop any vehicle, regardless of how minor that may be. And in this case, it was a rather minor allegation of left lane violation.
He was driving in the left lane.
He was getting in the left lane, and rather than pass the truck he was trying to pass, he dropped back and went back in behind him, and therefore didn't overtake the vehicle. But he was sort of presented with a Hobson's choice of whether or not to speed or to abort the passing movement. And in any event, he was stopped, and he was detained and questioned for over half an hour.
And the clock starts running, and that clock's very important.
The clock is all important because a detention, a vehicle stop, may only be of a duration and scope consistent with the underlying reason for the stop, which in this case was nothing more than a traffic violation. So an officer is required to expeditiously issue a ticket, give a warning, and then allow the motorist to go on his way, unless a records check proves to show, which they're entitled to do that expeditiously, that there's an outstanding warrant of arrest, the person doesn't have a valid driver's license, they have no insurance, their vehicle's unregistered, whatever, that would allow them to detain further. But in this case, all of that was clean. He had no warrants, but he continued to detain him because he just had a hunch that this guy is involved in going to purchase marijuana. So he tried to get a dog there, and he couldn't get a dog there quickly, and that's where the time comes into play. You cannot detain citizens indefinitely, and he didn't have a dog on board with himself, so he was trying to get a canine unit to respond to the scene. And a canine sniff, where a dog that's well trained and has a pedigree for this, alerts to a vehicle, is probable cause to search the vehicle.
No dog.
No dog.
No dog, no drugs.
No, and then so what made this case different and what makes it a landmark case is that realizing this and having exhausted his time and then some, he lets him go, but he's already established where he's headed, and then he calls ahead to another department. This was an NHP trooper. He called ahead to Elko County Sheriff's Office. Get a dog unit out to I-80. This is where I just let him go. He's mile marker, so forth. He should be, measure it. You can be in the right spot for him and intercept. Find a reason to stop this guy and have a dog with you. I'm telling you, he's carrying money, and that's exactly what they did. And so they did this leapfrogging thing. And that officer said he observed another independent traffic violation, giving him the right to do another stop, sniff the vehicle with the dog, which the dog alerted. But there was no drugs, which is an interesting manifestation. Some people might say that, many do, that these dogs are not accurate, or they're cued, or whatnot. But anyway, they then found the substantial sum of money in the vehicle, and the Ninth Circuit held that you cannot break up a single Fourth Amendment violation into several different units in order to try to salvage it.
That clock got him.
That clock got him. It was, and then of course the second stop, the second search, the second detention, the search of the vehicle, all of that was fruit of the poisonous tree, as they say, of the original stop.
Can't undo it.
Can't undo it. The evidence is not admissible. And you can't. And in that case, of course, they were seeking. There was no criminal case because there were no drugs found. There was no arrest made. They were just seeking to forfeit the money.
It's a really important case from Las Vegas' perspective, because even if you aren't a person of means, every now and then somebody gets lucky. Gamblers travel with a lot of money.
Yeah.
And to take that money away, he could have gotten it from any place. The idea that you can't travel with cash is one of the most un-American ideas that I think anybody's ever come up with.
Well, money that is, or any asset that's derived from the proceeds or is intended to be used in a drug transaction.
But they don't know any of that.
They don't know any of that.
They can't prove it. I've got a hunch. I got a feeling.
Right, and so they tend to do is when they run into a large sum of cash, the immediate presupposition is that a legitimate guy doesn't go around with a couple of $100,000 of cash.
So you win in district court, and the Obama Department of Justice turns around and they won't appeal, right? They
appealed. The government appealed to the Ninth Circuit, and the Ninth and they got special permission to do that, because you have to do that, and they got DOJ approval, as you point out, and the decision was affirmed by the Ninth Circuit in a decision that for the first time really talks about this business of. And this was an interesting technique. When I encountered this, I had never had a scenario like this before. Well, I'll let him go. I'll notify another law enforcement officer to intercept him, and if he can allege an independent basis to stop him, and we'll be okay. The Ninth Circuit said, that's not going to work. And I expected, quite frankly, that the DOJ would file for a writ of certiorari in the Supreme Court of the United States in this case, and they did not.
What was the time frame on the entire case? Wasn't it a good 4 years from the original traffic stop to the Ninth Circuit's decision?
Well, let's see.
13
2013. It was early in 2013,
to 17.
and so and we got the decision in early in 17. So
Seems like a long time. Is that an unusual length of time for something like this?
no, it's not. For this type of matter to wend its way through the system, this is not uncommon. It's a civil matter, even though the entire investigation and the issues involved are those that are commonly encountered in criminal cases. They're criminal case issues, but it is a civil forfeiture. And civil cases are not on the expedited calendar of the appellate courts. They are not reviewed as quickly as criminal cases are, because often in criminal cases there may be a guy who's incarcerated pending appeal.
Did the gentleman finally get all his cash back, or how did that
He
end?
got all his cash back. He got all his attorney's fees reimbursed. He got interest, and he made money on the deal at the end of the day. And it cost the government, I don't know, it cost the government about 3 times as much as they took
It's a good result for him. when
to
it's
take
all
a
said and
shot
done.
at him.
It was fortunate that
this
yeah,
one was-
the fortitude and the finances to go ahead and keep pressing forward. A lot
The
of
only
people would not
reason
be
this
able to.
decision was rendered, which is now precedent across the United States, is because this fellow had the resources to hire good attorneys and to fight the case, and to, as a matter of principle, stood up for this issue. He could have very easily have been throwing good money after bad, but as it turned out, he was the victor in all respects.
No, what was the special caveat though in this case? Because this wasn't the United States versus the man who was pulled over. This was the United States versus
Versus the money.
$167,000. So
Right.
how did it become that the money became the defendant in this case?
The money is always the defendant, or the asset, whatever it may be, airplane, vehicle, real estate, is the defendant in a civil forfeiture action. A forfeiture action is when the government is seeking not to punish an individual for the commission of a criminal offense, but is seeking rather to take his asset, which they allege was acquired or intended to be used to commit a criminal offense. And that's the law. Money that was derived from a crime, even if no one is ever convicted of that crime, may be forfeited to the United States if the United States is able to prove in a civil case that that money came from some illegal activity or was going to be used in an illegal activity. And because it's a civil case, it's not required to be proven beyond a reasonable doubt like a criminal case is. It need only be proven by a so-called preponderance of the evidence, which is a much lesser burden of proof. So it's much easier for the government to get a case like that. Now, if they make a simultaneous arrest at the time of a seizure of a sum of money, and they find drugs in conjunction with finding money, that makes that case a rather easy case for the government to prove. And again, as you point out, one of the only viable defenses to a case in that situation would be an illegal search and seizure that leads to the discovery of the evidence, which in all cases is a defense.
In this case, midway through the appeals process, the Department of Justice changed policy
Yes.
under the Obama administration.
Yes, they did.
Correct? Up until that time, there need not be some predicate crime going on. It just looked suspicious, and you could try to take the money, and
Yeah.
they said that wasn't fair. Do you think that's going to change?
Yeah, I do. I have heard Mr. Trump and Mr. Sessions already have made public statements. We're we're not going to continue on with that policy.
So Americans' cash is at risk. If somebody saves up and they've got a down payment, they got $20,000 in their pocket, and it's taken them who knows how long to put it together. They walk down the street, the cops pull them over. You shouldn't have the $20,000. That $20,000 is a risk, and unless you've got hundreds of thousands of dollars to pursue that, that may be the end of your $20,000.
It may very well be. The policy was changed, and as you know, there's a difference between law and policy. I mean, the law is still the same. The statutes of the United States still provide for forfeiture of assets. But what the Obama administration did after our case was to require that before a seizure, a forfeiture case could be filed in a federal court, the money, if it's money, must be found in conjunction with contraband or other evidence of criminal activity in order for it to be brought in a federal court. Now, this is a very important fact because they did no longer allow an inference to be drawn that simply having a large sum of money on one's person was somehow inherently suspicious. And we're going to take it, and we're going to ask questions later, and it's up to you to get a lawyer, and you hire a lawyer, and it's your responsibility to fight for your money back. It appears to me that the Trump administration intends to undo that policy and go back to where you can infer. Now, that doesn't mean that without some additional evidence that money is going to be forfeited in a court of law. But it is enough to get the money seized and to require you to fight for it, and require you to expend attorney's fees and so forth.
I think one of the most chilling aspects of this, as bad as it is for individual Americans, one of the most chilling aspects of this is what it does to law enforcement, and that is that it has the potential for absolutely honest law enforcement officials to become addicted to the cash flow of seizing
Let me tell you
cash
about.
from
Let me speak to
Americans.
that. I'll tell you right now. That's a very, very, very important point. Under the so-called equitable sharing program, money that is seized and that is then adopted by the federal government and a forfeiture case is filed in a federal court, 80% of them, if the money is ultimately held forfeitable by a judge, by a federal judge, and he finds that it was the proceeds of criminal activity, 80% of the money goes to the local law enforcement agency who seized it, and the federal government keeps 20. So there's a perverse financial incentive for local law enforcement, troopers on the highway, to make more stops, shake down more motorists, search more vehicles in hopes of finding cash that their department will wind up with 80% of if it is ultimately declared forfeit by a federal judge. And that money can be used to buy new vehicles, new equipment. In many cases, it's been used to have vacations, parties, and every other kind of thing. You'd be surprised.
When you think about it, police officers, law enforcement officials across the board that could never be bribed for any amount of money under any circumstances, would risk their lives to uphold the law, are the same people that have their bosses telling them to focus on the possibility of taking money because it funds the department.
Right.
If you're part of the team or you're not part of the team.
There are counties in the United States that are notoriously known to subsist on forfeiture seizures. You're driving through that county, the cops are out there looking to support the department in large part by and through seizures of money.
Especially on the cash seizures. I
Yeah.
know that Arizona has been notorious for that in recent years. Do you have any insight into that, or is that still a concern? Is that still going on?
Police officers going to Hawaii every summer.
Yeah, right.
From Arizona.
Right. I know there are some counties in the South, in Georgia and Florida, where this has been No, because they're on, they're on a known route. That there's a predictable high incidence of traveling with cash.
And the only way to change this is by changing the law, and that's simply not going to happen. You're basically writing a brochure against yourself if you're saying stand up for the rights of Americans. You're going to let the federal government seize this money?
Well, you don't really have to change the law as long as you enforce the Fourth Amendment. And a lot of judges may not necessarily have the courage to do that, and that's been my experience. But as the Ninth Circuit has specifically noted, the Fourth Amendment is at grave risk where searches are directed or motivated by forfeiture, as opposed to the seizure of assets, as opposed to the seizure of contraband or other criminal evidence. When they are in search of money, our constitutional right to be free from unreasonable searches and seizures is at grave risk because there's a financial incentive to violate the Fourth Amendment. Hey, commit as many searches and seizures as possible and let the judges sort them out, and try to get as much money together as possible. And even if a few of them get thrown out, let's commit. And the result is that more citizens are stopped, more citizens are detained, more citizens are searched. And of course, that's the ultimate evil that the Fourth Amendment is designed to prevent, absent justification. And I think there is an incentive for police officers who are otherwise noble and conscientious officers to sort of perhaps justify searches and detentions where they feel, well, this guy, is probably just some drug dealer anyway.
It doesn't take some elaborate lines of communication. Word gets out about these seizures. They seized the yacht of the Malaysian president, I guess, under the titular head of the country, worth $500 million, billion with a B, and the taxpayers own that now, own that boat until it gets turned into cash. And that trickles down. Everybody down to the sergeant, down to the grunt on the street knows that, if it's part of a crime, that's what you want to look for. And soon, maybe it won't even have to be part of a crime. Let me go whiplash back back to the Trump ordeal. What we constantly assuage our feelings and concerns about is that this is a country, unlike a lot of countries out there, is a country of laws, that the laws ultimately rule here. How have we done so far, do you think, in keeping the rule of law together under this just avalanche of accusations and firing the head of the FBI and all of these other things? How have we held up so far?
Well, I'm a great believer in the American justice system and our constitutional form of government. I've studied it, and I have stood up for it all my adult life in the practice of law, and I think we're doing pretty good. Now, I will say this: what's going on right now is highly unusual.
Amen.
Yeah, right. It's not unprecedented. The country has been through this with the Watergate debacle and the aftermath of all of that, and the resignation of President Nixon. And I was a young man in college when all of that was going on. And I remember it well. And what's going on now, I will say this, and I don't mean to in any way advocate any particular political point of view, but I'm not pleased personally with what I see. I'm not proud, certainly, of what I see. I don't. At least I will say this: I viewed Mr. Nixon as being more professional in his in his demeanor and in his public statements than I do Mr. Trump, and that's just a personal opinion. As far as, the president has the authority to appoint and his cabinet. That is his prerogative. But to fire law enforcement officers like Mr. Comey, head of the FBI, because they're investigating you and because you want to install someone more sympathetic to you personally and derail an investigation is problematic. And I find that to be the most problematic aspect of this whole thing. Much of this much of this I don't necessarily believe leads anywhere criminal.
We don't know that it attaches to Trump yet. That's the one thing we don't know. We know all of these other players, absolutely. Some of them have admitted it. Some have been indicted. Some of them are on their way to prison. We don't know. They all seem to point in that direction, but we don't know for absolute fact.
You have to let it play out and see where it does go or not go.
But conversely, if you look at the actions of this president, if he was completely innocent, why would he do the things that he's done, instigate the things that he's done?
Well, I'm not going to second guess that, because I'll tell you this. I don't put stock in anyone's assertion of a constitutional right or anyone's exercise of a prerogative of office as somehow constituting evidence of guilt. There's a myriad of reasons why someone may want to assert the Fifth Amendment in response to a law enforcement interview or a grand jury appearance or a subpoena that have nothing to do with being guilty.
But it sure looks that way.
Well, it may look that way, but as a lawyer, I would be very remiss.
In the court of public opinion, it sticks.
Well, also, as Vinny alluded to, President Trump essentially came right out and said, yeah, I had to fire Comey because he was getting too close with that Russia investigation.
Now,
in previous years and decades, that would have meant something, but
was that a mayor?
In 2018, for some reason, that just kind of floated on by and everybody went on with their lives.
If that was a mayor picked up on a wiretap talking about firing a sheriff, there would be your evidence of that guilty mind. They're as clear as could be. But when it's said on NBC News for the world to see.
Trump's also done a really good job in conjunction with, obviously, the Republican news outlets and everything, of sort of convincing your Republican voter and fellow American that Comey was wasting taxpayer money doing this investigation. There's so many other things more important and in need of investigation than what he was doing, and people sort of believed it and said, okay, yeah, fine, get rid of the guy.
I'm not as offended by that, frankly, as I am that I fired him because he's a showboat. More or less was stealing my thunder. I don't know how to interpret that. But
that's true. He was getting too much attention. He was on the cover of too many magazines.
I suppose. But action taken to derail a legitimate investigation could be interpreted as obstruction of justice. But I will say another thing, and I spoke to you about this, Mark, earlier before we went on. I kind of feel that the Mueller investigation, and I must say, in all fairness, it's in some respects going beyond his original mandate. I kind of feel that he's sort of looking to overturn every rock he can to try to find something.
Spoken like a true defense attorney.